Yeah, friends. In the earlier classes, we have discussed about the procedure for the amendment of the Constitution. Now we'll be discussing the important amendments of the Constitution. And these important amendment of the Constitution, I'll classify into four ways. One is the most general issues, and second one is like amendments related to the formation of new states, and third one is amendments related to the inclusion of official languages, and fourth one I say this is important, and this is amendments related to reservation. I can give another name for this, special provision for special classes. So this is how we'll be discussing. Now we'll be discussing about the general issues and as well as official issues, official languages. The first, we'll start with our constitution amendment. That is the first constitution amendment. You know the situation when India got independence, and the wealth of India was not equally distributed. So government of India wanted to go for distribution of wealth. So they went for the land reforms. So because of these land reforms, they created a new schedule, and that is ninth schedule. Ninth schedule was added to the protection from the challenge to the land reforms. Whatever the land reforms were enacted to protect those things, this ninth schedule was introduced. You know that the beginning, we had only 8 schedules. So this ninth schedule came into the constitution by the first amendment act in 1951. And also this has given effect to two articles. One is 31A and one is 31B. These two talks generally about that the government can acquire any property whenever it wants, and for the interest of the public. For the interest of the public, government can acquire some properties. That is what given with article 31A. And the date given here is, friends, this is the date from which date this Constitution Amendment Act came into existence. This is the date from which this act came into existence. Please remember. And second important act is 7th Amendment Act. See the date 1/11/1956. By looking at the date, you can say this, this is the date from which the states were reorganized. And we have discussed about when we are discussing about the first part and the first schedule also, we have discussed all these things. What are the states? And at the time of independence, we had 29 states, and now also we have 29 states. But the same 29 states are not here, and there was a demand for the separate language states based on the language, and government has constituted so many committees. At last, Fazal Ali Commission, or you say this is first SRC, State Reorganization Commission. So this Fazal Ali Commission has given a report to form states based on the language, and we got first linguistic state, that is Andhra state. And thereafter many states have gone for demand, and then this Fazal Ali Commission, based on this Fazal Ali Commission report, these 29 states which were earlier divided in 4 parts. Earlier these states were divided in 4 parts: part A, part B, part C, part D. This classification was demolished, and the new states were constituted. 14 states have created. Only 14 states out of this 29 have been created, and along with 6 union territories. This is what happened because of this entire procedure was included in the 7th Amendment Act. So based on the 7th Amendment Act, whatever the existing states classification is there, part A, part B, part C, part D, this was demolished and new states were created. So remember 7th Amendment Act in 1956, and it came into existence from 1st November 1956. And the third one we'll be discussing about 31st Amendment Act, and it gives the number of seats, maximum number of seats that can be there in the Lok Sabha. Now you have 545 seats. This was decided by the 31st Amendment Act of 1972. So earlier the number of seats in the Lok Sabha were 525. Now we have number of seats as 545. This is what 31st Amendment Act in 1972. Yeah, friends. And you can't increase the number of seats also, that we'll be discussing in later stages, while discussing this topic only. And we'll be discussing the next one is the 41st Amendment Act. This 41st Amendment Act of 1976, it states about the members and chairman of the Public Service Commission, exclusively state and joint Public Service Commission. State Public Service Commission and joint Public Service Commission, these commission's chairman or member, their retirement age is decided as 62. Earlier it used to be 60 years, but based on this 41st Amendment Act, their age was increased from 60 years to 62 years. So if you see this retirement age, it is like this, 6 years of service or 62 years of age. So remember this, either they complete 66 years of service or 62 years of age, whichever is earlier, that is applicable for the retirement. So 62 years of age was decided at the 41st Amendment Act of 1976. If you want to understand this thing, I will explain. See, a person has become a public service commission chairman at the age of 59. Like he can it means he can work for only 3 years. So by looking at 6 years of minimum, it is not 6 years of minimum service, it's 6 years of service. Don't say that he should complete his 6 years of service. Once he completes his 6 years of service, he becomes 65. So that is the reason we say the 6 years of age or 6 years of service or 62 years of age, whichever is earlier. This is about the State Public Service Commission. And I want to add one more important thing here. This is about UPSC, this Union Public Service Commission. Here the age is like this: 6 years of service or 65 years of age. So this was recently came into existence. 6 years of service or 65 years of age. Remember, for UPSC 65 years, and whereas state it is 62 years. For states it has came from 41st Amendment Act of 1976. And the next one we'll be discussing is 42nd Amendment Act of 1976. You can put you can go for a 5-star question. This is a very very important question, and you can take 5-star question as this question as a 5-star question. And this amendment was done at the period of emergency. Like in 1975, you know that India had a period of emergency that is based on internal emergency. There are many kinds of emergencies. One is internal emergency. Generally, internal emergency means there is a public order was completely disturbed, and so government cannot control the public order. So that is the reason they impose some emergency. So at the period of emergency, like in 1975, this 42nd Amendment Act was enacted. Okay, so this 42nd Amendment Act, how it came into picture? See, like in 1975, when there was a emergency, like a government wanted to go for amendment of the constitution. So they constituted a committee to look into the procedure for the amendment of the constitution and mostly possibility of the amendment of the constitution. The committee was headed by Swaran Singh committee. He has given some recommendation. Based on his recommendation, this constitution was amended, and some of the points were included. Some of the points were you see this importance, it is having some good points and it is having some bad points also. Yeah, the name for this 42nd amendment is mini constitution. See, this why this is mini constitution means it is having so many provisions, and this is the biggest constitution amendment ever made for our constitution, 42nd constitution amendment. So remember, 42nd constitution amendment is a biggest amendment, and it is also called the mini constitution, and it is based on the Swaran Singh committee. So what are the good things over here? Like here it has added it has amended preamble, it has added some words to the preamble. One is called socialist and secular and integrity. When we have discussed about this preamble, we have seen socialist, secular, integrity. These three words are added later stages, that is because of the 42nd Amendment Act. And you remember the date also, it came into existence from 1st April 1977. And you know that fundamental duties, earlier there were no fundamental duties. These fundamental duties were added under the part 4A, and article which discusses about this fundamental duties is 51A. This was added to the constitution, and also it has added 3 directive principles to the our constitution. One is equal justice and free legal aid, and participation of workers in the management of industries, and protection of environment and forest and wildlife. These three directive principles were added to our constitution based on this 42nd Amendment Act. And what are the some bad provisions which is given by this constitution amendment? The first one is it made president bound by the advice of the cabinet. See, whatever the advice given by the cabinet, that is called a supreme. So means it made parliament as a supreme thing as compared to the president. If a cabinet wants to give an advice, some advice to the president is bound to follow that advice. He is not having any he is sending back to the sending back for the reconsideration purpose. The general procedure for the for anything recommendation to the president is once thing is given, recommendation given by the cabinet reaches to the president can send it back for the reconsideration. So this is how the process works. Of course, they may accept it or may not accept it. Once they send back, the president has to accept. That is another issue. but this procedure was this was controlled, and made the president was not allowed to send back for the reconsideration. So made the president bound by the advice of the cabinet. Whatever the advice is given by the cabinet, that is final. And whatever the constitutional amendment is done under this based on this 42nd Constitutional Amendment Act, so that is beyond the judicial scrutiny. Judicial review was not applicable for this whatever the constitutional amendment is done based on this 42nd Amendment Act. That is was the procedure, that is what the inputs given to the constitution by this 42nd Amendment Act. And also you see here the life of Lok Sabha, you know that the life of Lok Sabha is only 5 years, but at the time of this emergency period, because of this 42nd Amendment Act, it was increased to 6 years. So life of Lok Sabha has become 6 years. So you can this is at the time of 5th Parliament session. That was the 5th Parliament of India. So so we can say that this 5th Parliament of India is the longest tenure worked parliament. They worked nearly for 5 years and 10 months. So lengthiest parliament session of India is the 5th Parliament. Remember this point, because of this extension of Lok Sabha period, that is from 5 years to 6 years. And also as we discussed that this whatever the amendment is done in this particular period, that is not bounded to the judicial review. It is beyond the judicial review. And it also facilitated for the proclamation of national emergency at any part of India, and also given extension to the president rule. President rule is generally for 6 months, but under this 42nd amendment, by the 42nd Amendment Act, it was extended to 1 year. It also controlled Supreme Court and also High Court. It curtailed the power of judicial review, and writ jurisdiction also it has curtailed. And there are some, this is what given by the 42nd Amendment Act. That is the importance of 42nd Amendment Act. So now we will be discussing about the 43rd Amendment Act. So under this 43rd Amendment Act, we have seen what we have seen in 42nd Amendment Act was the power of judicial review and writ jurisdiction of the Supreme Court and High Court was that was limited. So now it is restored back under the 43rd Amendment Act. So whatever the bad things were done under the 42nd Amendment Act, so those were restored under the 43rd Amendment Act and as well as the 44th Amendment Act. So now we will be discussing about the 44th Amendment Act. It is having the same importance as of 42nd Amendment Act. It is also a 5-star question. And if you see, this is in 1978. And in 1978, the Congress government has lost the election and Janata Party has formed the government. So whatever the bad things were done to the constitution, this Janata Party has got some remedies for that. So what are the remedies they have shown here? So in the earlier amendment, the period of the Lok Sabha was extended to 6 years. Now this 44th Amendment Act has brought it back to only 5 years. And the provisions of the government, the government has so many provisions to proclaim the internal emergency. So these provisions of the government were limited to proclaim the internal emergency. And Article 352 talks about the constitution amendment, under the Article 352, government can go for internal emergency based on the armed rebellion, based on the internal disturbances. If the government can cite a reason that there are lots of internal disturbances, so that I want to go for emergency period. So this is a danger concern for the people of India. So this under this 44th Amendment Act, this internal disturbances was replaced by a word called armed rebellion. Means because of the internal disturbances, means whenever there is armed rebellion within the country, then only the country go for emergency. So this was the again one more amendment done under this 44th Amendment Act. And as earlier we have discussed that the decision made by the cabinet was final, and the president is bound to accept that recommendation given by the cabinet. So now this under the 44th Amendment Act, the president is empowered to send the whatever the advice is given by the parliament back to the parliament. So earlier only one-way communication, these people will decide, the cabinet will decide and president will accept. Now he has got the power to send it back. That is what also done under this 44th Amendment Act. And also Like president can go for emergency situation. The president can go for announcing the emergency only on the written recommendations of the cabinet. So earlier president can alone go for the announcement of the emergency, but he can't go for the announcement of the emergency on his own. Like he should have a written recommendations of the cabinet. So that is what given with the 44th Amendment Act. And also at the time of emergency, like article 20 and 21 are suspended. Like the 42nd amendment has made a provision for the suspension of this 20 and 21st. So under this 44th amendment act, it has given such a provision that these cannot be suspended during the national emergency. And also one more important fact we need to discuss here is it has deleted the right to property. Earlier the right to property was a fundamental right. So under this 44th amendment act, this right to property was deleted as a fundamental right, and it has made only legal rights. Remember, you may get a question in the exam, the fundamental right to property is not considered as a fundamental right, because of which constitutional amendment. You should answer 44th amendment act. Yeah, this is what the importance of 44th amendment act, friends. Now we'll see the 52nd amendment act. So we have discussed this 52nd regarding 52nd amendment act. We have got the 10th schedule because of this 52nd amendment act only. That 10th schedule is also called anti-defection law, we have seen. So what is this anti-defection law? As I explained, if one person won election from one party, let us say X party, after winning the election he will join in the Y party. This is a defection. So what are the provisions to disqualify the member of that party X who have migrated to party Y after winning the election? Those kind of things were incorporated in anti-defection law. This is called anti-defection law. So it provides disqualification of members of parliament or assembly in case of defection from one party to another. So this is what about 52nd amendment act. So remember, 10th schedule is added by the 52nd amendment act, and this 10th schedule is also having another name, that is anti-defection law. And the next one we'll discuss is this, again an important thing, 61st amendment act of 1988. So this lowered the age of earlier the voting the age limit to excise or franchise is 21 years. Now it is brought back to 18 years based on the 61st amendment act. And the next one we'll discuss is 65th amendment act. This is has got some special provision for special classes like scheduled caste and scheduled tribes. So they have provided national commission for scheduled caste and scheduled tribes. So this is a joint commission. There is no separate commission as per the 65th amendment act in 1990, and it came effect from 1992. So there is no separate provision, separate commission, only it's a joint commission for both the classes, scheduled caste and scheduled tribes. Only joint commission was there. And next important thing is 73rd and 74th. This is a question can be expected in any exam if their syllabus, polity syllabus is applicable for in any exam. You can expect a question from 73rd amendment act or 74th amendment act. This is a damn sure question on these two amendment acts. Yeah, what the 73rd amendment act says, it has granted the Panchayat Raj institutions came into picture because of this 73rd amendment act. And what is this 74th amendment act says? Urban local body, talks about the urban local bodies. What are the urban local bodies? Municipalities. So this is the importance. 73rd Panchayati Raj, 74th municipalities. And you know that we have how many parts? Yeah, we had 8 schedules in the beginning. 9th schedule is added now, and 10th schedule is also added just by 52nd amendment act. And this is, now we will discuss about the 11th schedule. 11th schedule is added by 73rd amendment act. Remember, 11th schedule is added by the 11th schedule is added by the 73rd amendment act. And also we have got part 9. This is renamed as Panchayat. This is entitled as Panchayats. And this schedule, whatever the 11th schedule is there, it is having 29 functional items. You may get a question in the exam. The number of functional items under the 11th schedule, that is 29. The article, the part which is entitled the name of Panchayat, that is part 9. And 74th amendment act, and it came into existence, sometimes the dates also important. It is 24th April 1993. And the 74th amendment act also came into existence from 1st June 1993. Yeah, it granted constitutional status to the urban local bodies, and we have got a new part in the parts, that is 9th A. 9 talks about the panchayats and 9A talks about the municipalities. And also we have got a new schedule, that is a 12th schedule, and it is having 18 functional items. Remember that it is earlier it is having a 73rd constitutional amendment is having 29 functional items, whereas 74th constitutional amendment has given 12th schedule, and this 12th schedule has got 18 functional items. Here 11th schedule is having 29 functional items, here 12th schedule is having 18 functional items. Yeah friend, these are very very important. And next one we'll be discussing is 84th Amendment Act of 2001. So what is this 84th Amendment Act? So it clearly said, like we have seen that we have how many number of seats friends, like we have 545 seats. These the number of seats cannot be changed till 2026. This is what 84th Amendment Act says. So this classification was done on the base of 1971 consensus, and you can't change the number of seats to till 2026. You can't increase the number of seats till 2026. But there is a small provision provided, but you can reorganize the constituencies. But you can't change the number of constituencies, but you can reorganize the constituencies, like a rationalize and readjustment of the territorial constitutions. That is based on the 1991 consensus. You need not follow the 1971 census, and you can go for 1991 census. That is what given by the 84th Amendment Act in 2001. And what about 86th Amendment Act? This is again an important act. So here we have changed 3 items, like we have discussed when we are discussing about the fundamental rights and fundamental duties, and as well as directive principles of state policy. See, based on this 86th Amendment Act, what happened is, like Article 21A was added to the fundamental rights, and elementary education was made as a fundamental right. Fundamental right means it is a duty of the state shall to provide free and compulsory education to children aged between 6 to 14 years. So this is what provided in the fundamental rights. So Article 21A clearly talks about the free and compulsion education. See here, compulsory education it is. So all the children who are between 6 and 14 years, they should be bring them to the school, and they should be given education. That is what compulsory education means. So this is what about Article 21A. And also we have changed the context of Article 45. Earlier Article 45 used to talk about the children from 0 to 14 years. Now as rights of children from 6 to 14 years is included in the fundamental rights. So this has brought back, the definition is brought back in the DPSP to 0 to 6 years. So in the Article 45, the state shall provide early childhood care and education to all the children aged between 0 to 6 years. This is a directive principles of state policy. 0 to 6 years is a directive principles of state policy, and whereas 6 to 14 years is a fundamental right. So every citizen is entitled, and the state must provide those things. And we have also added one more thing, that is a fundamental duty, that every citizen of India, whether he is a father or guardian, so he should see that the child between 6 to 14 years gets sufficient education. So that is the fundamental duty of every citizen. That is what given by the 86th Amendment Act in 2002 friend. This is very important. Yeah, next we will discuss about is 87th Amendment Act, and what it has given is, like in the earlier thing we have seen in the 84th Amendment Act. What we have seen in the 84th Amendment Act, like the constituents can be like regrouped based on the 1991 consensus we have said. So but based on the 87th Constitution Amendment Act, so it is not 1991, it is 2000. So based on the 2001 census, like you can readjust the number of constitutions, but total number of constitutions should not change as 545. This is the importance. And see the 89th Amendment Act of 2003. So earlier we have seen that there is a National Commission for Scheduled Caste and Scheduled Tribes. So it is a joint commission. Now these commissions were split, and separate National Commission for Scheduled Tribes and separate Commissioner for Scheduled Caste was created under the 89th Amendment Act. Remember that 89th Amendment Act. And the next one is 91st Amendment Act, friends. This is very important again. So based on this 91st Amendment Act, what happens is, like the number of ministers in any government should not exceed 15% of the members, like that should not exceed 15% of the total number of union or state legislatures. See, this is the importance. And if you see about the state legislature, like a number of, like the minimum number of ministers should be 12, and maximum should be like 15% of the total members. So this should be the limit. So minimum 12 ministers should be there in a state. So this is what given by the 91st Amendment Act. And the next one is 96th Amendment Act, and it's a simple thing, like the name Oriya was replaced by Odia, like we have substituted the name Oriya to Odia. This is from 96th Amendment Act. And the 97th Amendment Act, and again 97th and 99, these are also important. This 97th Amendment Act has created a cooperative societies. This is very important. 97th Amendment Act talks about the cooperative societies, and the right to form cooperative societies like included under the Article 19. It has become a fundamental right. And also under directive principles of state policy, like under 43B, that the state should promote these cooperative societies. This was made under the directive principles of state policy. Yeah friends, and we'll discuss about the 99th Amendment Act and 2014, very recent one, like it has got president assent also, and it came into picture from 13th April 2015. So it talks about NJAC, National Judicial Appointments Commission. It provides the formation of NJAC. So this is about the 99th. And 100th constitutional amendment, it is in the pipeline, like we may get it very soon. This is exchange of exclaves and enclaves with exchange of land with Bangladesh. So this is what friends. And if you see this 99th Amendment Act, this see act and bill is a different thing. It was the 127th bill friends. So bill number is also important. It is a 127th bill. And Constitutional Amendment Act is the 99th Constitutional Amendment Act. You may get a question whether on the bill, or you may get a question whether on the act. Mostly you won't get a question on the bill, but you may get a question on the like act. So this is what about the 99th Amendment Act. And we'll see the official languages. We know that the first one is 21st Amendment Act. Based on the 21st Amendment Act, Sindhu was added into the official languages. And 71st Amendment Act, like there are 3 more languages: Konkani, Manipuri, Nepali were added in the 8th schedule. And 92nd, you add this 21st and 21st, and you add like 71st, you will be getting 92nd. So next act is 92nd Amendment Act, and it has given 4 more languages. So earlier, how many languages were there friends? Only 14, and Sindhu was added 1, next 3 were added, and next 4 were added. These 4 were Dogri, Bodo, Maithili and Santali. So these are the things, like now it has become like 22 languages. So overall 22 languages are there. This is what the class is friends. So official languages are 22. So this is what the class is. And like us, like our video, and you can share our video also. And don't forget to subscribe VFocus classes. And if you have any queries, you can mail us at vfocusclasses@gmail.com. Thank you very much, and have a nice day.